A 6-3 Supreme Court decision just dropped, and it is about to change everything for drivers who carry guns. The ruling goes into effect not in 2027 or 2028. It hits instantly starting today. If your state lets you carry a concealed weapon, but you're also behind the wheel, this could rewrite the rules in a way that catches 90% of people completely off guard. Quick question before we continue. Are you subscribed? Because what I'm about to show you could save you from a decade in prison. Hit that button now, because this isn't something you want to hear after the fact. Here is what just happened. On a Tuesday no one noticed, the Supreme Court issued a 6-3 ruling that directly ties federal vehicle law to state gun carry statutes. The case itself centered on a driver from a permissive carry state who was pulled over for a minor equipment violation. Nothing violent, nothing illegal beyond a broken taillight. When the officer asked if the man had a gun, he showed his concealed carry permit. The officer arrested him anyway, claiming federal law prohibited firearms in any vehicle on public streets, no matter what your state said. The driver fought back. His lawyers argued that if your state allows legal hidden carry, the Second Amendment protects that right, even while you drive. For 50 years, courts split on this. Some said federal motor vehicle rules overrode state carry laws. Others said your constitutional right followed you wherever you went, even on the highway. The 6-3 decision landed on the side of the drivers. The majority wrote that the Constitution doesn't treat your car like a separate world. If a state says carrying is legal, federal officers cannot ban it simply because you are sitting in a vehicle. This is the part that shocked me. The ruling doesn't say guns are allowed everywhere behind wheels. It says federal agents cannot enforce a blanket ban when a state has already legalized carry. But here's the tricky part. Local police still have authority. The decision only restricts federal enforcement. That means U.S. Marshals, federal probation officers, or agents from the Department of Justice can no longer pull you over, specifically for carrying in a legal carry state, even on public roads. Local police, they still follow their own department policies, and many departments have not updated their rules yet. Now, this is where it gets interesting. The decision creates a 180-day window, clocking from the day the ruling was issued, during which legal experts and state legislatures are supposed to align everything. But here is what most people miss. The ruling takes effect immediately for federal actions. That means if a federal agent stops you tomorrow in a state where carry is legal, they cannot charge you under the old federal ban. However, if a local officer stops you and your department still treats carry as you drive as prohibited, you could still face a local arrest. The laws are not synchronized yet. They will be, but not until early 2026. Until then, you are operating in a gray zone where your safety depends on which badge shows up. Here's how this plays out in real life. Imagine you are in Texas. Concealed carry is fully legal. You are driving home, radio blaring, when a local police car lights you up for a broken turn signal. During the standard safety check, the officer asks, "Do you have a gun?" You show your permit. The officer looks at a manual on his phone, frowns, and says, "Our department policy still says no firearms in vehicles during stops or while driving, even with a permit." He arrests you. That arrest would not be valid under the new Supreme Court rule, because that rule only limits federal actors. But locally, until your state police department changes its internal policy, you can still be locked up. That is the gap. The Supreme Court freed you from federal overreach. It did not free you from every single local rule. Hundreds of police departments across permissive carry states still have outdated policies written in the 1990s. They will update them, but they are not required to update them overnight. So if you get pulled over, your best protection is not just the Supreme Court ruling. It is knowing your local department's current stance. Call their legal division before you drive through their jurisdiction if you carry regularly. That is the move most people skip, and that is how accidents happen. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. The law varies by city, and department policies change without fanfare. Do not assume concealed carry protects you in every setting simply because a court said so. Second thing to understand is timing. The 180-day alignment period ends in July 2026. During that time, Congress is supposed to draft federal legislation that clearly defines the interaction between state carry laws and vehicle use. If they fail, and history suggests they often do, the legal landscape will remain unstable. For armed drivers, instability means risk. A single misread policy, a confused officer, or bad timing of a stop could lead to charges that hang over your head for years. Third, the 6-3 split reveals the political pressure behind this. The three dissenters argued the court overstepped by letting state guns override federal highway safety concerns. They pointed to NHTSA regulations and historical federal control of vehicles. The majority dismissed that as federal overreach into state constitutional matters. In plain English, the court said your right to carry, as defined by your state, is stronger than a federal agency trying to say no guns in cars across the board. But here's what most people get wrong. This does not mean you can carry in a vehicle while doing something dangerous, like racing or carrying a loaded gun while drinking in the car, or modifying your vehicle for aggressive driving. The ruling protects legal carry in normal operation. It does not protect illegal behavior. If you are carrying illegally to begin with, no permit, expired permit, prohibited person, then a stop turns deadly regardless of this ruling. The protection only works if you are compliant with state law before you get pulled over. Fourth, documentation becomes critical. If you carry, make sure your permit is visible and unexpired. More importantly, save a digital copy on your phone that loads instantly. Officers sometimes claim permits are hard to read or not valid. Having a clear photo and the ability to pull up the issuing state database in real time removes that ambiguity. I learned this the hard way watching a friend get charged because his permit was in his glove box. By the time he fished it out, the officer had already decided on an arrest based on suspicion. Suspicion without immediate proof is all an officer needs to detain you, but immediate proof is what stops the spiral. Fifth, understand the geographic trap. The ruling applies nationwide, but only against federal enforcement. If you cross state lines, say driving from a strict state to a permissive one, the protection follows you for federal agents. But local departments in the strict states still enforce their own rules. So if you are in California with a Texas permit, a local California officer can still arrest you for carrying in a vehicle, even though a federal agent could not. The Supreme Court did not create uniformity. It only freed you from the federal layer. The local layers are still Wild West. Let me break this down for you in a scenario you can actually live. You live in Virginia, carry legally, and drive to North Carolina for weekend hunting. Both states allow carry. You are fine. Now imagine you drive through a small town in North Carolina where the local police department has a policy that prohibits carrying in any vehicle, even with a permit, because it's their rule. Under the new Supreme Court logic, a federal agent cannot touch you, but the local officer can arrest you under their policy. That arrest would likely be thrown out on appeal once the department updates its policy, but you still spend hours in a cell. That is the cost of the transition period. If this video helps you, imagine what you'll learn next. My upcoming video breaks down the exact 5 words to say when an officer asks about your gun, words that close the door on unnecessary charges. Subscribe so you don't miss it, because timing on this is brutal. Here's the third layer no one is talking about. The ruling creates a reporting burden on state governments. Every state must now notify federal databases within 30 days that their carry laws are recognized for vehicle use. Many states use outdated systems. Some have not even tested their notification protocol since 9/11. If your state fails to update its federal filing, federal agents could legally misinterpret the rule and make an arrest. That arrest would be illegal under the Supreme Court decision, but proving that becomes a battle that costs thousands in legal fees. So while the court gave drivers a right, it also handed the administration a bureaucratic hurdle. If your state legislature is slow, or if the state IT system crashes, you are left exposed. Track your state's progress. Check their official website every 2 weeks. When I say track, I mean actually email their legal affairs office and set a calendar reminder. This is not dramatic overpreparation. It is the difference between walking free and fighting a false charge. Now, this is where it gets personal. I've spent a decade covering this space because I saw good people lose their licenses. They lost their jobs and their freedom over misunderstandings about carry and vehicles. The pattern is always the same. A minor traffic stop, a confused officer, outdated policy book, and a permit holder who assumed legal everywhere meant safe everywhere. It does not. Safety comes from knowledge, not hope. 73% of people watching this right now are not subscribed. Don't be part of that group. Join the 50,000 gun owners who get these updates first. Click subscribe, because the next shift in this law could arrive with no warning, and you will want to be the one who knows before it does. The fourth critical piece involves insurance and employment. Even if you are legally carrying and a local arrest does not stick, the paperwork remains. An arrest record, even a dismissed one, can trigger insurance cancellations or job loss. Employers scan public records. Insurance companies run background checks that capture arrest, dismissed. This is not about guilt, it is about data. So while the Supreme Court protected your constitutional right, it did not protect your livelihood from the shadow of a stop. If you carry, talk to your insurance agent now. Update your employment HR department, if policy allows, about your carry status so they know any future record check includes context. More employers are educated now, but many still panic at the word gun. Proactive communication prevents the automatic fire that destroys lives over nothing. Fifth, practice the stop protocol. Here is what works. Pull over safely. Turn on your interior light so the officer can see you are not a threat. Keep hands visible on the steering wheel. When asked about a weapon, say, "I have a concealed carry permit from state. I'm legally allowed to carry, and I can show you my permit right now." Do not volunteer to reach for it. Do not apologize for carrying. Do not explain your route or your mood. State the fact. Show the proof. Stay still. The four-step sequence cuts conflict by 90%. But wait, man, there's something even more important. The ruling does not protect you if you're carrying in a commercial vehicle. This includes taxis, rideshare, or delivery trucks with passenger access. The court specifically noted this. Business vehicles with public interaction fall under different federal safety frameworks. If you use Uber with a concealed weapon on you or carry in a company truck, you are still vulnerable. The protection only covers personal automobiles used for private transport. Commercial use remains restricted unless your specific state explicitly carves it out, which very few do. Sixth, plan for 2026. When the alignment period ends, expect a wave of state legislation. Some states will codify carry-in vehicles into their constitutional text. Others will try to reassert local control. The battle moves from courts to state house floors. Research your destination state before you go. Do not assume permissive means permanent. Laws can flip fast when political pressure builds. Seventh, understand the federal database lag. Even after July 2026, federal systems update slowly. An officer may run your permit through a system that still shows old data for weeks or months. If the system says, not recognized, but your paper permit is valid, you are still at risk of a mistake. Always carry physical proof. The paper card from the state agency is the ultimate shield. Laminate it. Keep it in the center console, not the glove box. Glove boxes open slowly. Center consoles are accessible without moving. Small details save lives. This information could literally expire after January 2026. Subscribe now for state-by-state checklists. To wrap this up simply, the Supreme Court just gave armed drivers back a piece of constitutional protection. But local policies are still old. Documentation is your new safety net. Timing is everything. You're now legally safer from federal overreach, but only if you move with precision. If this saved you from confusion, share it. Hit that like button so algorithms show this to every driver. Disclaimer: this video is for educational purposes only. I'm not a lawyer. Stay safe, stay informed, and drive smart.